Well, welcome everybody and thank you for joining us on this webinar. Our webinar today is on privacy and investigations, and I'm joined by my colleagues Camille and Tessa to talk to you about privacy and investigations. So just to give you a bit of background for myself, I'm a partner in Field Fisher's privacy team. And I've worked in the area of data protection for about 25 years now, and during that time have seen many investigations. And I've worked both in-house in data protection officer roles as well as for law firms. I'll hand over to Camille and Tessa to introduce themselves.
Hi everyone, I'm Camille Ebden. I'm a director in our London Technology and Data team as well, specialising in data protection. I've been with the team since 2016. My work on investigations has included large, complex global data breaches, as well as suspected fraud and employee malpractice matters. And most of these I've worked on with Carsten. So I'll hand over to Tessa.
So whilst Tessa sorts out the sound, we'll just introduce Tessa. So Tessa is an associate in our tech and data team and also works on investigations and particularly has been involved in working on. So what we'll cover today. So we're going to look specifically at sort of different types of investigations and personal data handling considerations. So we're not going to look at everything to the nth degree, but we're going to pick on some really key issues that we see coming up quite regularly and that we recommend you pay close attention to. So starting with whether you need to carry out a data protection impact assessment when you're conducting an investigation. Then we're going to look at some of the key activities that might come out of that, like identifying your lawful basis, putting your privacy notices in place, and setting the parameters for your investigation, as well as some considerations around engaging third-party providers to assist you with an investigation. So it's really just to have a look at, and talk about what are the sorts of investigations that we might be talking about here. Well, first off, it might be a whistleblowing investigation, for example. So you might have allegations of bullying or harassment of one employee against another, and you've had reporting through a whistleblowing hotline, or however you take in that information. It might be an investigation into a personal data breach. So you might have become aware of an incident that's happened or a potential incident which you need to look into and identify what's happened, what personal data is involved, what measures you need to take to remediate the incident. It might also be, for example, that you suspect that there's been a fraud internally and you want to investigate and perhaps even bring in external third-party providers like auditors or forensic providers to help you to understand what's gone on here. And all of these types of investigations could well involve processing large amounts of personal data, or even if it's not large amounts, it could actually be really quite sensitive personal data. And that brings an added level of complexity to your investigations because you really need to sort of pay very close attention to what you're doing from a data protection compliance perspective. So if we just move on to the next slide, Tessa. So the first thing that I would recommend is that you do carry out a data protection impact assessment, or at the very least sort of have a check as to whether you need to do one. But I think in these sorts of investigations, it's usually fairly safe to assume that you're going to need a data protection impact assessment. And that's because it's mandatory to carry out an assessment if you're processing personal data that's likely to result in high risk to rights and freedoms of data subjects. Now, if we move on to the next slide, Tessa. So this all derives from Article 35 of the GDPR and the UK GDPR. Now, you would be forgiven in thinking when you look at the sort of the few sub-bullets in Article 35 that you don't need a data protection impact assessment. And so what it actually says is that particularly if you're carrying out public monitoring or systematic and extensive profiling with significant effects, or large-scale use of special category personal data or criminal convictions or offences data, then you should be carrying out a data protection impact assessment. So you could be forgiven for thinking, well, actually, I don't think we're doing those things. We probably don't need a data protection impact assessment. But this is where the European Data Protection Board guidance also comes in. So if we pop on to the next slide. So the European Data Protection Board, which is made up of lots of data protection regulators, and this is where they sort of give opinions on how we do compliance under the GDPR. What they've said is that there are certain triggers for a data protection impact assessment and where you ought to be carrying out these assessments. So it's not really just limited to those three activities that I mentioned on the last slide. So what the EDPB, as they're referred to, say, is that you should be carrying out data protection impact assessments if any of these 9 criteria are triggered. Now, usually it's that if you have 2 or more triggered at the same time, but sometimes it could just be one of those that triggers a DPIA. And what I've done here is on the top row, and you'll see in the green boxes, I've put the criteria that trigger a DPIA most relevant to an investigation. And I'm not going to go into detail on the blue ones, but so that you have the full picture, I've put them there, and they can sometimes be relevant. But the really key ones are the top boxes in green. So if you're carrying out large-scale processing, you need to carry out a data protection impact assessment potentially. Now, why would you be carrying out large-scale processing in an investigation? Well, it could be that you've had a personal data breach and you need to go through your customer databases, your employee databases, or other sets of personal data and quite large volumes of it to understand what's happened. You might have had a whistleblowing, and you might need to have a look at through your customer databases or look at what vendors are doing. Has there been any untoward wrongdoing going on there? And you might actually also be trying to match or combine data sets, and this comes up typically in a personal data breach. So to give you sort of an idea of an experience that we sometimes have, you might have suffered a breach where you've had a bad actor's got into your systems, potentially, and taken data from your system. And then there might be postings on the dark web or otherwise online where they're saying, we've got your data, here's a sample. And they will post a sample data set. Now you need to identify, is that actually your data and did it actually come from your systems? And that might require you to do matching and combining of these data sets just to try and, and identify whether it's a breach that originated from you. And in doing that, you might also want to carry out systematic monitoring. So again, just from a personal data breach perspective, this comes up where with bad actors, they might say, we're going to post this information on the dark web, or you suspect they already have. So you might need to be monitoring to see whether there's personal data popping up in places that it shouldn't. So that could be personal data monitoring. But you might also need to do monitoring in your systems to see whether the bad actors are still there. Or even taking a step back, you might actually be implementing some security measures and software and systems to actually monitor your platforms to make sure that the bad actors are not getting in, but that in itself could involve processing of personal data. So, for example, a tool where we regularly carry out data protection impact assessments is if you have data loss prevention systems implemented where you're monitoring what employees are sending out of the business. You might also be processing quite sensitive information that is highly personal in nature, particularly if you think about whistleblowing, where there might be allegations against individuals that you need to investigate, or it might in fact actually even be allegations of criminal processing, criminal activities. And that might come up in a personal data breach as well. So you might suspect that there's been a fraud, or you might suspect that there's been a breach in your systems, and you need to monitor to identify what's happened. And you might ultimately identify an individual that has actually carried out these criminal activities. And you might also be carrying out processing in a way that the data subjects can't exercise their rights, or because they might not even know about it. You might be processing relying on an exemption to provide privacy notices and transparency, and in which case data subjects can't exercise their rights. Or even if they do know about it because you've provided privacy notices and that was a possibility, because of the investigation, if, say, a data subject comes to you and says, I want you to stop processing my personal data, then you aren't necessarily going to be in a position to stop processing it because you still need it for an investigation. So that in that way, they can't exercise their rights. So as you can see, there might be all sorts of triggers that are coming out of this European Data Protection Board guidance, which would dictate that you need a data protection impact assessment. And I would say if in doubt, it is a good idea to do one anyway, because it forces you to go through and look at all of your compliance obligations from a data protection perspective and understand how you're going to comply with them. Thank you, Tessa. If we pop on to the next slide. Right, and this is just a reminder that if you are carrying out a data protection impact assessment, it's a mandatory requirement that you have your data protection officer involved. So that's if you have one in place, you need to involve them. And I would say make sure you get them involved really early on, and in fact do your data protection impact assessment really early on, because there might be activities coming out of that data protection impact assessment that could take a little while to implement, and you want to get that done before you actually start processing the personal data as part of the investigation. Thanks, Tessa. Over to you.
Thanks. I'm hoping that this is working now. Can you all
Much
hear me?
better. Yes.
Okay, good. Finally. Thanks, Kirsten. So one of the things that will definitely come out of your DPIA is that you need to look at your privacy notices to check that they cover the processing, which is done for the type of investigation that you want to do. So depending on the investigation, there may be various privacy notices that you need to check or make sure you have in place, as there may be a number of different categories of data subjects who will have their data processed during the course of the investigation. So you need to consider what data are you going to be sifting through for the investigation, whose personal data you may be looking at, and whether they have been informed or not. So for whistleblowing investigations, you need to think about, has the whistleblower, the staff, and other relevant individuals received a privacy notice explaining how you will handle data protection as part of the investigation. For fraud and breaches, you may be looking at personal data from all of your staff, including mailboxes and things like this. So you may also be reviewing interactions with vendors, customers, website users, a whole array of different data subjects. So for example, where you have suspected fraud, this might involve customer money. So you're looking at customer interactions. Or where you have a breach involving your website and you need to look at website logs, that may be a situation where that occurs. So also, sometimes the incident is unanticipated, or it's not possible to provide a privacy notice at all. So, for example, if you have a hacker and you're trying to identify who that hacker is, obviously you've not got the opportunity or probably not the intention to give the hacker a privacy notice. So where you cannot provide a privacy notice, then you should look to see if the circumstances fall within an exemption of the GDPR or UK GDPR, and if any other local exemptions apply, such as organizations are exempt from the GDPR's transparency provisions, where the information is required to be disclosed by law or in connection with legal proceedings, or where it involves disproportionate efforts. So it may also be that some countries are more permissive than others when it comes to relying on exemptions. So definitely something to look out for. Next slide, please. So what should you actually have in your privacy notice? First off, you can easily tell staff in your employee privacy notice that you might need to do investigations, and that, for example, their emails may be reviewed as part of this. We also suggest making sure that all relevant information to investigations is covered in all of your other privacy notices where appropriate, such as your supplier and customer notices. We also recommend having a separate whistleblowing privacy notice in addition to your other notices, especially the notice for your staff. This is because a notice needs to cover a lot of specific details when it comes to whistleblowing. And also a separate notice is really useful as you may need to provide a privacy notice to data subjects who are not employees. This way, the notice can easily be provided just in time as a pop-up to whichever individual is using the whistleblowing system. In addition, we recommend ensuring the principal standards established within the Irish Data Protection Authority's decision regarding WhatsApp's privacy notice is taken into consideration. And that's because this has really set the benchmark for privacy notices across the EU. And even though it doesn't apply to the UK, it's definitely something that most people are taking note of and incorporating. So since this decision, there are extra requirements in relation to accessibility, granularity, and clarity. By way of example, here on the screen, you can see a snippet of our whistleblowing privacy notice template. And here it really shows the sort of extensive detail that's now required from privacy notices. You can see even when we need to list the relevant laws where you are relying on legal obligation as a lawful basis. So all of this means that there is a new added level of detail that needs to be applied with a breakdown of the investigations and processing activities which may take place, the data processed, and the lawful bases that you're relying upon. Next slide, please. So when completing your DPIA, you should be considering whether you have a lawful basis for the different processing activities employed during the investigation. And in practice, what lawful basis you rely on can really differ from country to country. From our experience for non-special category data, performance of a contract and public interest can't really be relied upon by most organizations. Although compliance with a legal obligation could potentially be relevant for heavily regulated industries and for the collection and processing of personal data for whistleblowing purposes due to the EU Whistleblowing Directive. However, this may not necessarily be appropriate, as often ethics hotlines collect more information than legally required, and the personal data is used for more than just whistleblowing matters. So that's just something to take note of. Most entities will have to rely on legitimate interests as the lawful basis, especially in relation to individuals who are under suspicion, as they cannot obviously be told about the investigation, and therefore consent is not appropriate in these cases. Although you're actually quite unlikely to want to rely on consent at all, regardless of the data subject, as you don't want any sort of withdrawal of consent to hamper the investigation. Therefore, consent really should only be relied upon as a last resort. Something to remember is that where you do rely on a legitimate interests as the lawful basis, you need to complete a legitimate interest assessment as well. Next slide, please. It should also be remembered that you may be processing special category data. For example, information on race or sexuality may be processed if you're dealing with a whistleblowing discrimination case. In these instances, you not only need to have a lawful basis under Article 6 of the GDPR, but you also need to look at Article 9 and identify a special condition for the processing of this personal data. So as mentioned previously, consent would really only be relied upon in exceptional cases only. Alternative Article 9 conditions that may be relevant include the processing is necessary for the establishment, exercise or defense of legal claims, or for carrying out the obligations and exercising specific rights in the field of employment. This might be relevant where, the employer has a duty of care to the employees and may have a legal requirement to investigate, such as under health and safety laws. Necessary for reasons of substantial public interest may be relevant for some organizations. For health and safety related issues, there may be a case to rely on reasons of public interest in the area of public health. For example, if an employee is being investigated for not complying with COVID-19 safety procedures. It's also important to look at whether specific member state law might have expanded on the GDPR conditions or introduced further conditions as well. Thanks. So it's also another point to remember is that you may also be processing criminal data. For example, information on criminal offences may be processed where suspected fraud is being investigated. If you are processing criminal data, then you need to have an Article 6 lawful basis. But where you're not processing for law enforcement purposes, you must also process that personal data in accordance with whatever the local laws are. So you'll need to look at the local law and see if the processing is authorized. So in the UK, as an example, doing an investigation in an alleged criminal offence into an alleged criminal offence is considered criminal data, and the conditions for processing are found under Schedule 1 of the Data Protection Act 2018. And something to remember is that some, but not all, of these conditions may require you to also keep an appropriate policy document in relation to that processing.
Great, thanks very much, Tessa. So when starting an investigation, in order to be data protection compliant, you're going to need to set some parameters for the investigation. Now, some of the key parameters are going to be based around the principles in Article 5 GDPR. Some of those principles, such as transparency and lawful basis, Tessa's just covered. But looking at the others, a key first principle to consider is data minimization. So under Article 5 GDPR, you should only process personal data that is adequate, relevant, and limited to what's necessary for the purpose of the processing. So you therefore need to think about what data in particular you're looking for and what data will be irrelevant to the investigation purposes. This will guide you to determine what systems to search, what data within them actually needs to be looked at. When running searches, you'll need to limit the search to relevant data categories and subject parameters. There might also be format limitations that you can apply. For instance, just emails with PDF attachments sent between person X and person Y, between date A and date B. So secondly, we've got the principle of purpose limitation. So data can only be collected for specified, explicit, and legitimate purposes, and not further processed for incompatible purposes. You therefore need to be very clear with all the investigation team about the scope of what they can use the data for. This should be limited to purposes strictly necessary to carry out the particular remit of the investigation. So, for example, if an employee's inbox is being searched as part of an investigation into a suspected fraudulent activity by them, you should be careful to not use the data found for any other purpose, such as, for example, to assess whether the employee has complied with non-related policies, such as rules regarding them to delete emails from their mailbox after a certain period. So then if we move on to accuracy, you need to ensure that the data you're using for the investigation are accurate. In a whistleblowing investigation or an investigation of fraud, you need to consider whether someone could have tampered with the investigation data, for instance. If there's been a report with allegations of fraud or bullying, the purpose of your investigation will likely be verifying the accuracy of those allegations, but there's also a data protection obligation to verify the accuracy of the report. In the context of a data breach, it's very important, of course, to work out where the relevant data subjects are based globally so that you can consider the relevant data breach reporting laws. Often with evolving IT systems, if a more historic database using old codes has been compromised, then there can be some uncertainty as to the accuracy of customers' locations, for instance, and further steps might need to be taken to check the data. Again, in the context of data breaches, if you decide not to notify data subjects, if you decide you are going to notify data subjects, are you confident that the contact details you have for them are reasonably recent and therefore likely to be accurate? You, of course, don't want to compound a data breach by contacting the wrong person about it. Fourthly, we have storage limitation. So you should ensure you have retention policies in place with reasonable retention periods for the data you'll be collecting as part of the investigation. You'll need to think about what is a reasonable period in terms of your processing purposes and also the time frame for legal claims, litigation, and criminal investigations in the relevant jurisdictions. There can also be legal requirements to retain data for certain periods of time, and these can differ from country to country. We also note there are some specific whistleblowing, retention, and deletion rules that vary by jurisdiction. You will also want to consider whether you can keep any of the data in an anonymized form. And also if you're using third parties to assist with the investigation, such as forensic investigators, make sure you've agreed retention periods and anonymization practices with them. Fifthly, we've got the principle of security. So under the GDPR, you of course need to ensure you are appropriately protecting the personal data processed for the investigation in accordance with the risk. In investigation scenarios, data is often sensitive, as we've discussed, and you don't want unauthorized individuals to stumble across it or for bad actors to gain access. For instance, you don't want to compound a hacking situation by having your internal confidential communications about the hack also hacked. In a whistleblowing situation or a situation where there are allegations against an employee, you don't want other unauthorized employees to gain access to the investigation data and change it, whether accidental or actually intentional. You might even need to restrict access to databases and systems that would generally be used by a broad range of employees as part of business as usual in order to protect it from being inadvertently changed. In whistleblowing investigations, be aware that there can also be further legal requirements to restrict access. So you need to think carefully about who will have access to investigation communications and data and how you will limit access to those individuals. The access controls that you put in place might even perhaps include a separate platform to prevent anyone unauthorized from gaining access to, say, communications about the investigation. Also, if you're using third parties to support the investigation, you need to ensure that you're comfortable that they will adequately protect the investigation's data. And so on that note, I'll turn to our next slide, please. So another key consideration is whether you need or want to appoint third-party providers to support your investigation. Now, reasons for having someone external could be to ensure the investigation is fully separated from the personnel implicated in an investigation. For example, Kirsten and I supported a client on a suspected fraud investigation where the key suspect was in the IT and security team. It was therefore important to have an external investigations team to avoid that suspect being tipped off and interfering with the investigation, and to avoid the investigations team having any conflict of interest. Another reason could be because your own organization doesn't have the resources or perhaps the expertise to carry out the investigation. So for instance, in a data breach involving the dark web, you may well need cybersecurity experts to help you investigate. And a further reason could be if your systems themselves are compromised or they're not sophisticated enough, then you may also need external support. So that brings us to the question of, well, who should appoint the third-party vendors? Should you appoint them directly, or are there benefits to your external law firm appointing them for you? Well, it can help with asserting privilege over any vendor reports, such as forensic reports, for external lawyers to appoint the vendor. Privilege can be harder to assert for in-house lawyers who may have a dual role within the business where they perform both legal and commercial functions, and also where they're receiving or sending communications that have a mixed commercial and legal purpose. Often for our clients, we will appoint forensic investigators rather than the client, and we set out in the terms of engagement that with the vendor that this is to enable us, the field fisher lawyers, to advise our client on the legal risks. So then we've got the question of, well, should the third-party vendor be positioned as a controller or a processor? To answer this, you'll need to assess the nature of the involvement of the third party. In most cases, you are likely to not want to have the vendors be able to use the data for their own purposes, so they'll most likely be positioned as a processor. Worth noting, though, that when it comes to external legal counsel, depending on the jurisdiction, they may be viewed as controllers in their own right because of their overriding professional duties. Next, it's vital to ensure you've got suitable data protection terms in place with any third-party providers. Most providers will already have their own standard terms, but as data protection law is fast-moving, you should check the drafting covers the latest data protection requirements and that the descriptions of the processing are accurate. A good example is the next point regarding data transfers. So larger investigation organizations may operate digitally from anywhere in the world. If so, then you'll need to consider whether data is being lawfully transferred under data protection law. For example, you might need to add in standard contractual clauses or have a transfer impact assessment in place. Now, this all obviously takes time, and often in an investigation, you need to appoint someone quickly. So when preparing ahead for future investigations, you may want to put in place retainers so that you already have everything set up with external legal advisors such as Phil Fisher or any forensics and/or forensic providers. So this can make things much speedier during urgent situations. And just to mention here that Phil Fisher does have a cyber breach retainer offering, and we also have investigations vendors that we have already contracted with on behalf of our clients. So you also need to make sure that you've got appropriate security measures in place with the third party. Now, you need to particularly keep in mind the types of data involved and, of course, where it's been transferred to, as we've just discussed. And as also mentioned earlier, often investigations and whistleblowing scenarios will involve special category data, and they may involve data relating to criminal convictions and offences. So you need to take care to ensure the security measures that the vendor has in place are appropriate. Right, so then over to Kirsten and the next slide, please.
Thank you, Camille. So, one question that we'll often get asked is around, well, what's the risk? What if we're not doing these things or haven't done these things? So we're going to take a look at that. Now, the risk is, I'd say, probably heightened in terms of your non-compliance with data protection obligations in these investigation situations. And that's because let's take, for example, a personal data breach, it might be the case that you yourself are required to report the breach to a regulator. You might find that another controller has reported it. You might have data subjects that have reported it, and you come to the attention of the data protection regulators. So they are looking into what you're doing from a data protection perspective. And if you've got areas of non-compliance, it may well come out during the regulator's investigation. In fact, there's one instance from a whistleblowing perspective, which is another risk of potentially the data subjects themselves telling regulators, and that was in Italy, where a whistleblowing system was implemented, but without thinking about all of the data protection compliance behind it. And in that particular case in Italy, the controller and the processor were investigated, and the Italian data protection regulator found that there'd been breaches in a number of areas, including, there was tracking and monitoring going on of data subjects without their knowledge. There wasn't a correct privacy notice. There was no data protection impact assessment carried out when it should have been. So that's an example of, like, a real life example of how you may come before a regulator for other reasons and then get investigated. The other reason is that if say in a whistleblowing context, for example, you're dealing with an investigation into individuals, and they know they're being investigated, there may be disciplinary action going on. If you haven't done everything data protection compliantly, then actually you're giving that data subject some levers that they can use against you, and with the threats of reporting to a data protection regulator. And data subjects themselves can be a risk, because they might be aggrieved over your non-compliance and feel that they've suffered harm. They may well report it to a data protection regulator, but they themselves could also bring claims for your breach of data protection. And then not to forget that there's also the reputational damage angle here. Say in a personal data breach situation where it's in the public domain, actually to salvage your reputation, you would want to be able to show that you are a trustworthy controller, and that people can trust their data to, and you do things compliantly, but in the instance, you couldn't have prevented this incident. So that's how you might want to be presenting yourself, but it's made more difficult if there are areas of non-compliance in the background from a data protection perspective. The next slide, please, Camille. Oh, you're on mute there.
Thanks, Kirsten. So that actually takes us to our key takeaways, which we've put into a checklist format. So, as discussed, you need to carry out a data protection impact assessment. And you'll need to do this for high-risk personal data processing, or if there's sensitive data or any of those other factors that we mentioned. And you'll need to put in place appropriate parameters and privacy measures that will come through as part of that data protection impact assessment, including, as we've discussed today, identifying and documenting your lawful basis for processing. And don't forget about special category data requiring a condition as well. And also don't forget about criminal offences type data. You'll also need to, as Tessa explained, check your privacy, that you've got relevant privacy notices in place that cover the investigation, or if you haven't, check that exemptions apply. Then you'll need to make sure that you've got appropriate data protection contract terms in place with any third parties. And lastly, you need to make sure that your own and any third-party security measures are adequate to protect the personal data that you're processing as part of the investigation. And I think that's it from our content. So any questions? And I think that there is a little box where you can type questions. Oh, Kirsten, I think you're on mute.
Sorry. So yeah, please do send us your questions either through that box, or if you've got any questions that you want to follow up with after the webinar, please do get in touch with us. So while we give people a little bit more time to post their questions, I'll actually start with a question that I sometimes get asked, which is, can we start the investigation and then do the data protection impact assessment? Because often, there's a need for speed to get on with the investigation. So technically speaking, the idea is that you do the data protection impact assessment first, so you've done that before you start the processing of personal data, but there are always these, pragmatically, there are these situations where it's imperative just to get on with it. I mean, for example, if you've had a personal data breach, you want to get on with the investigation, you've got other data protection obligations to comply with there, and you want to do what you can to protect data subject. So it really is a balancing act, but more often than not, I see controllers that they will crack on with their investigation. But what I would say is then, do get your data protection impact assessment in place as quickly as possible, and all of those activities that fall out of that data protection impact assessment, get them buttoned up as quickly as possible as well. And don't forget as well that it remains a living document, that data protection impact assessment, because things change all the time, so you will need to keep going back to that and revisiting and reassessing. So it looks like we haven't had any questions from the audience. So as mentioned, do get in touch with us if anything occurs to you later on. Then we'd be happy to speak to you. And I think we'll end the webinar there. Thank you everybody for joining us.